Hello, everybody, and a very warm welcome to the Property and Investor Podcast. I am your host, Paul Lanfear. And as you know, my inner lawyer always has to start with the same thing, which is nothing in this podcast is health, legal, or financial advice. Naturally, you'll do your own due diligence. And I am genuinely thrilled to invite to introduce my guest today, Suzanne Smith. She's a former in-house counsel. We'll talk about that later on. She's a blogger, she's a podcaster, and not only that, she's a professional landlord, but also she speaks a lot of sense and has a really great overview of the legislative impacts that I think we're going to see over the next few years with the new government. So, Suzanne, warm welcome to the podcast.
Thank you.
Now, when we originally scheduled this podcast, we were going to talk about a few different things, and maybe we'll get to those towards the end. I hope we will, but we'll have to see how we do for time. But we're obviously coming straight off the back of the King's speech. And full disclosure, this is the first King's speech I've ever listened to and watched. And I think the reason for that was because you prompted me to, by very, very kindly suggesting that we do the podcast just after the King's speech so we can talk about it. So, tell us what did we learn in the King's speech?
Well, in the King's speech itself, the King didn't actually say that much, other than saying there was going to be new legislation that would give, and I'm reading, greater rights and protections to people renting their homes, including ending no-fault evictions and reforming grounds for possession. That's all the King said. But alongside the King's speech, there's this big document that comes out for journalists, and I got my hands on it, and it set out what's going to be in the new bill, which is not going to be called the Renters Reform Bill. It's going to be called the Renters Rights Bill, which is very Labour. Workers' rights, renters' rights. It's all from the.
But isn't that interesting? Like already straight out of the gate, there's that change of emphasis. Renters' rights has a very different feel
Yeah.
than it does renters' reform, which is fascinating, isn't it?
It is, because obviously, as a lawyer, when there's a contract, there are rights and obligations for both parties, and is focusing on the renters' rights. But it is two ways. We as landlords, our duty, our obligations are to provide nice places for people to live in that are decent, and to do repairs, and to be a good landlord. That's what we have to do, and in return, they need to pay the rent and look after the property and let us know if anything needs repairs. So it's very much a two-way contractual relationship, and the emphasis on this bill is renters' rights. And the funny thing is that the word renter doesn't even mean anything in law, because when you look at the law, it's tenants all the way through it. And the Renters Reform Bill, the only place it mentioned renters was at the beginning. It's tenants all the way through. So it's just a bit of branding, a bit of Labour branding after the Michael Gove branding for renters reform.
Yeah. So, obviously, for as long as I can remember, we've been talking about the previous incarnation, the Renters Reform Bill, and there's been lots of chopping and changing. There's been a lot of fear mongering as well. There's been a lot of clickbait. There's been a lot of horror stories, which I don't think helps anybody. So I think, you've got a really interesting approach to this, which I really like. You clearly lean in to your skills as in-house counsel. And for those that don't know the role of in-house counsel, it's the chief legal officer who effectively shepherds the company or business through the legal minefield. But what's extraordinary about in-house counsel is they have to know everything about everything. They have to understand the business, but also they have to know all kinds of, I'm going to use the word bizarre, if you don't mind, like bizarre bits of legislation, because they have to hold the ship together. And what's fascinating is you bring that into property. And I suppose that's what we're going to lean into today. So you interpret the Renters' Rights Bill for us. Tell us what the headlines are. Tell us how you think it could impact us.
And also, when you're an in-house lawyer, just to build on that briefly, is that you're always having to interpret new legislation. We had GDPR not long ago, and we've had, all sorts of things, and the rules for listing of companies and competition law, everything. There's all stuff that keeps coming at you all the time when you're in business. So for me, I have had a steep learning curve to learn about landlord and tenant law, but it is transferable, and so I bring that what does this mean for us approach to looking at the law as if I'm advising my colleagues in a company. But of course, I, like you, I don't do legal advice, and everything I do on the Independent Landlord blog is free, and I do not give individual advice. And I'm no longer a practicing solicitor. So I still have I'm still on the roll, but I'm not a practicing solicitor. So I repeat your caveat. Anyway, so about the renters' rights bill. It is very similar when you look at the notes to the King's Speech to the Renters Reform Bill, and some of the provisions in it seem to be a cut and paste job. There are a few new things that were signalled during the election campaign. And actually, incidentally, in the election campaign, renting didn't come up a huge amount.
Yeah.
I was surprised. I was expecting it to be made more of during the election. There was a lot on planning and building new houses, but not much on renting, apart from Keir Starmer mentioned in one of the big speeches about ending the bidding wars, and that's
Yeah.
something that actually wasn't in their manifesto, but it is in the King's Speech notes.
Yeah.
And they mentioned about tenants being able to challenge rent increases, which
Mhm.
they can already if it's a Section 13 rent increase. But anyway, it is very similar to what's in the Renters Reform Bill. But as always, the devil will be in the detail. And with the Renters Reform Bill, there was a lot of detail that still hadn't actually come out. And
Mhm.
so Labour will have to do that now.
And that's the fascinating thing, it's all what's of interest is as much as what isn't in it at this stage. For example, and forgive me if I've missed this, but I can't see anything about EPCs. Um,
Yeah, you're right there. Yeah, there was nothing
EPCs
in
was
the yeah, I did a word search in this big document for the briefing notes for energy efficiency and EPC. There was nothing in there was nothing in the King's Speech about EPCs, even though that was in the Labour Party manifesto, although they didn't say what EPC landlords would have to improve their properties to by 2030. There's nothing in the King's Speech, and it was never in the Renters Reform Bill anyway, because it's a different bit of government.
Yeah, and which is fascinating because I mean, I think if you were to take like a straw poll of landlords, I think it's fair to say they feel like they're under attack and that they don't feel supported by any incarnation of government, which I think is probably true. But you look at the EPC, the suggested EPC changes. I mean, I know of landlords who have left the market because of that, and I know that we've taken a really serious look at some of our properties. Some of our properties are big old Victorian beasts, and for one of them to meet a C, it would have cost £30,000
Wow.
to have done the work.
I can believe it. I have Victorian properties as well, and I might buy one more.
Mhm.
But I would never buy a property that's an E again.
Yeah,
And I do have one that's an E, because it's not just the cost of upgrading it, it's the time, and you can't do most of it with the tenants there. So
no,
I bought a property. It was my first intentional buy to let. I bought it 5 years ago, almost exactly, and it was an EPCE, and I didn't really understand what that was at the time,
yeah,
and I thought, oh, it'll be all right, and so since then I have spent well over £10,000 upgrading it.
yeah,
So there's the boiler. I put in insulation in the cellar. The ceiling was coming down anyway, so it made sense to put that on. I've replaced most of the windows, not because I did it for the EPC, because you don't get much of an uplift for the windows, but because they were rotten. And
yeah,
but then that cost me an absolute fortune to get good quality ones. And I put insulation in the loft. I'm hoping that that's going to be enough to get an EPCC. Certainly, there are other properties on the road that have an EPCC that have similar things. My other ones are all EPCCs, but that's a lot of money to pay out of cash flow in 5 years that I've spent, 15 grand, whatever. And it's fine in the south where we have good rents and I can pay that out of cash flow, but in the, over 5 years, not in 1 year, I'd struggle. Yeah, I have to dip into savings for that. And actually that's a big thing. There are so many people going into property investing who stretch themselves to the maximum and keep recycling their deposit and don't have a cushion, don't have money, a sinking fund in case something goes wrong. So this week I did, it's an inspection, but I don't call it an inspection. I call it a maintenance visit because it's a bit more, I don't know, it's a bit more collaborative with the tenants. And I went round, the house inside was perfect and wonderful tenant. And when I went outside and I was parking, I had a look up at the roof, and the next door's roof was slightly higher, and the wall, that is his wall, the render had come off, and you could see the brick underneath, and there was no pointing. And I thought, oh my God, it's another thing. So I've been talking to the next door neighbor about whose liability it is, because we'll have to get a scaffold, and I'll probably need to put flashing on my bit around the chimney, and that kind of thing happens all the time. And so if you don't have it, you have boilers that break, you need to stash money away if you're a landlord.
Yeah, you do. You need to be
And
very liquid. You need to have lots of cash reserves.
yeah.
Yes, and that often isn't in the marketing. Anyway,
Sorry, it's a digression, but it's what the property gurus don't tell you.
no, but I think it's definitely a
Yeah.
valuable one. So we've got this kind of blank space where we don't really know what the future of EPCs is. We'll kind of have to kind of hold our breath on that. One of the issues that certainly was in the King's speech, but it's interesting what the spin has been in the run-up is this immediate abolition of
Yeah.
Section 21. So talk to us about the
Yeah.
immediate abolition of Section 21.
When I saw that in the Labour manifesto, I rolled my eyes. And on the podcast that I do, Good Landlording, we put something out in June, and I just said that immediately doesn't mean immediately. That's just rhetoric. It's just marketing spin. There's no way, we don't have the system of law by presidential decree. Things have to go through Parliament. And what I suspect happened is that they might have done the first draft of the manifesto thinking that the Renters Reform Bill would already be on the statute book. And so it would just be a question of implementing something that's already received royal assent. But because it didn't receive royal assent in the wash-up period just before the election, it means that Labour have to start again. And if the bill is anything like the size of the Renters Reform Bill, which was 206 pages, then that takes a while to go through the legislative process, and particularly because it's not in the list of bills that has been published between now and the summer recess on the 30th of July. So it won't even start going through the House of Commons until the autumn. So yeah, immediately, it doesn't mean immediately. It means it's a priority, but it's not going to happen, anytime very soon.
And obviously going side by side with that is the potential new ground for possession under Section 8.
Yeah.
So Section 8, is particularly used when you've got the appropriate level of arrears for that to kick in. And obviously it's a court-based process, and it's a process that requires enormous attention to detail. The forms need to be correct, the dates need to be correct. And, we've had, unfortunately, letting agents who just haven't managed that process very well. They're just simply not being able to do the process well. And so that in itself is a challenge. But anyway, moving on from that, there's going to be new grounds, aren't there? And one of those grounds deals with, as I understand it, if I, as a landlord, want to sell the property.
Yeah.
Can you tell us a little bit about that?
Yeah.
And
Well,
also,
first of all, Labour haven't confirmed in any detail what the new grounds will be. So just a kind of a recap. At the moment, if a landlord wants to get possession of their property, they want to evict the tenant, or for whatever reason, they serve a Section 21. You can't do that during a fixed term tenancy, and you've got to give 2 months notice, and most tenants move out when they get it. And that's the bit that's going to get away. You don't you could going to go. You don't need to give a reason. That's why they call it no fault. But if the tenant doesn't move out, you still have to go to court to get the bailiff. You can't just go in and say, sling your hook. So what landlords are going to have to use instead is Section 8, which is already there. And that's where you have to have a ground for possession. You have to prove it to the judge that you have the ground for possession. And there are two types. There's mandatory, which means if you can prove it, then the court will give you an order for possession, which you've then got to enforce. And then there are discretionary ones, which means the court will have to decide whether it's the right thing to evict the tenant because of this. And the Renters Reform Bill had a lot of new grounds, and one of them was a mandatory ground 1A, which would enable a landlord to obtain an order for possession if they wanted to sell the property. And they could give that 3 months into the tenancy, which is actually quite short. Labour at the time did not disagree with having that as a ground for possession, so they were in favour of it, but they wanted it to be served after the first 12 months, if I remember correctly from their amendment. So the chances are that ground for possession will be in the Renters' Rights Bill. And there were some other new ones to make it a little easier if there's rent arrears or antisocial behaviour. We don't know if they're still going to be in the Renters' Rights Bill, but in the King's Speech notes it said that clear and expanded possession grounds plural, will be introduced so landlords can reclaim their properties when they need to. So that's encouraging, but we don't have any detail on that yet.
And there was a ground in relation to if as a landlord you want to sell your property as well, but
that was that one, the ground 1A. That was the if you wanted to sell.
But how does the mechanics of that work if I put my property on the market today and for one reason or another it doesn't sell? What's the practical consequences of that? I'm baffled by that.
So under the Renters Reform Bill, the landlord would be unable, if a sale fell through and the tenants move out, would be unable to relet the property for a certain amount of time afterwards. And I think that was 3 months from off the top of my head. Labour wanted it to be longer, so and they couldn't let it on a serviced accommodation on Airbnb. So that is not a kind of backdoor eviction, because I think the renters groups were concerned that people would just say, "Oh, I'm selling," but they're not, and that's probably not an unfair suspicion to have. So there will be kind of anti-avoidance language in the new bill, definitely.
That's really interesting, but possibly not as bad as we were maybe led to believe. I mean, I saw some really like spicy clickbait stuff saying that you're never going to, you're never going to be able to sell your house ever again and that kind of thing. I mean, that's not the direction of travel from what you say.
I know, and there has been so much of it, and normally it's by people trying to sell you services. Might be letting agents and they do it so people will click through, and so that's what I've been trying to do with my blog is I've got nothing to sell. I'm a landlord. I'm just trying to figure this all out myself, and so I write what I interpret it to be. Sometimes I get it wrong. If I get it wrong, I correct it. But I always provide the primary sources. After leaving work as a lawyer, I retired 5 years ago, and then I did a French degree at King's College London for 3 years, and I learned in the modern world what it's like to reference everything when you're writing academically. And that's what I do with my blog. You'll see links all over. I don't just make stuff up. It's always so like I'm looking at the blog post in front of me now about the King's Speech. And so I'm talking about what Labour said in the House of Commons in the committee. And then it says, see Amendment 255, and there's a hyperlink. They can go and look at it. And so that way it's factual information interpreted rather than trying to be all doom and gloom and get people worried where they're worrying unnecessarily.
Yeah, definitely. I mean, one of the themes of the podcast we might try and return to later is that I think optimism is a superpower, particularly in this day and age, because you hear so much doom and
Yeah.
gloom. Um, and it's interesting listening to your podcast. I mean, I don't think I've heard you say it explicitly, but one of the themes I take from your really fantastic podcast is
Thank you.
that it is very positive. It's
Yeah.
acknowledging that we're facing all of these challenges, and let's not be naive about it. But it's also, well, and now we just need to put our best foot forwards, make the best of it, continue to, as you say, your strategy is offering great housing to lovely tenants. That in theory that should work for the rest of time, shouldn't it? Anyway,
Yeah, no, and I agree with you. And I do have a prepare for the worst, hope for the best approach as well. So I'm not naive, but I think going forward, what's really important is tenant selection, and
yeah,
then looking after your tenants. If you get good tenants, you've got to look after them. And I think that all landlords should be more involved in the process, even if they use letting agents. And unfortunately, a lot of letting agents are useless. I do know of some that are good, so they're not all bad. But I have personal experience of useless letting agents, which is what led me to start finding my own tenants and using open rent, and then writing the blog. And these were, they're big, well-known letting agents. They've got, all of the accreditations and things, but their customer service was poor, and the people actually in the office doing the work didn't have level 3 accreditation. They didn't know what they're doing. And I mean, to give you an example, my daughter yesterday, she called me and, very upset about their they're wanting to replace a tenant in their HMO, and the landlord said they have to re-reference everybody and charge them for it. And that's just wrong. The letting agent can charge £50 for the form to change it over, but they can't charge tenants for referencing. That's against the Tenant Fees Act, and that's actually really serious. And so I did a nice little email for her to send, and then they kind of said, oh, no, you misunderstood.
yeah, of
So,
course, of
and
course.
and this was just some guy, young guy. I looked him up, but he didn't have any training at the letting agent, and just not knowing. I don't think that they were being dishonest as such. I think it was just incompetence. What, not incompetence. I mean, it's just lack of knowledge.
Yeah,
And I think that we can't, as landlords, leave things to the letting agents. You can't let and forget.
yeah,
You can delegate, but you got to supervise. It's just the same as when you're in the work environment. If you empower people, you let them get on with it, but you still check in with them.
yeah,
And so that's why I recommend that landlords, if they use agents, should still do a property visit once a year, just to make sure that the property's in good condition, and chat to the tenants and see that they're okay, and make sure that things are fixed properly and
definitely.
promptly.
There's apparently a Russian proverb which is trust but verify.
Yeah, exactly. Yeah, no, I think I've used that one a fair few times. Yeah,
It's really educating.
definitely. Yeah,
But
because
I think,
you can't rely on people to do things, particularly something where you've got a legal obligation, many
yeah,
legal
yeah,
obligations as a landlord,
yeah,
and there's nothing wrong with checking in on them, and to go on a visit, and just to see what the state of the property is. It's a big investment, and things go wrong. And I bet if I'd had a letting agent, they wouldn't have noticed the future problem I'm going to have with the roof that I mentioned, because of the render coming off the wall of the next door's house.
yeah. I think that's very true. I think I mean, there's much that can be said. We may circle back to that later. I think you're definitely right about the fact that tenant selection is absolutely crucial. That landlords do need to. I know that we kind of check every single tenant that comes through our door, even though we use agents. We're very careful about the criteria. We're pretty fanatical about having a UK home owning guarantor, because that historically has just been the best thing for us. Actually, the deposit system has been less successful. Um, I think you're right that I like, on a slightly pessimistic note, I think the downside of this for renters is that landlords who half a decade ago would have taken a chance on somebody if the numbers didn't add up but they looked at them in the eyes and thought, you know what, you deserve a bit of a break. Like those days are well and truly gone, I would say, because the regulatory environment just isn't supportive of that. I mean, one of the things we didn't touch upon, but just I suppose to plant the seed, not plant the seed, but I suppose just to like at least reference it in the podcast, is that even if you do have grounds under Section 8, you're still under, we still need the court process to
Yeah.
be effective and in your favour. And we know that our courts have been chronically under-resourced for such a long time that that's not necessarily going to be available to us. So even though you've got a mechanism you can use, the practical, whether it's going to practically deliver what you need in the timescale you want is just a different question altogether. But aligned to that, your recent uh, podcast and article prompted me about Section 13. So obviously we know we've still got Section 13. Tenants can still challenge our rent reviews. I think the lesson that we've learned, I'll be interested in your perspective on this, is certainly pre-COVID, we were not doing annual rent reviews. We
Mhm.
were really slipping. Like if it was a good tenant who was maintaining the properties, the property, we would largely leave them to it. And I know that doesn't sound great from a business perspective, but I'm just being honest. Section 13, now under this new regime of under a Labour government, where they are, I think, going to there's going to be an invitation, I think, to challenge excessive rents. Um, it doesn't it make it more important to do an annual rent review now?
Well, yeah, I mean, uh, I think that it was understandable, in the older days, not to increase rents because inflation was low, and we had years and years and years of low inflation. But we all had a bit of a shock the
Yeah.
last couple of years, and the cost of everything went up, insurance, materials, everything, and landlords are affected by that as much as tenants. And so, if landlords don't put up the rent, they're reducing it in real terms. And I use all the time the Bank of England calculator. You can put in, say what you paid for a property 5 years ago and see what it's worth in today's money, or you can put in the rent that you first did 5 years ago and see what it is today, just for you to stand still, taking
Mhm.
into account the inflation. So for rent reviews, 'cause most of my tenants are fairly recent. So I think the longest one I've had is 3 years, just because I've been going for 5 years.
Mhm.
And the one who I had, the two I had the longest, have gone on, the first two ones. And I'm quite near market. I'm a little bit below market rent for the ones I've let recently, and there are somewhere I'm slightly, I'm a bit further below market rent, but um, I've got really good tenants. I want them to stay. But apart from COVID, I've always put up the rent. And this year, my approach is my approach last year and this year is to do the lower of wage inflation and CPIH. And that's the CPI with the housing costs in it. And last year, I used wage inflation as a top because CPIH was really high. It was 10% or something, which I thought was too much for my tenants in 1 year when wage inflation was like 4 or whatever. This year, the positions are reversed and wage inflation is higher, but CPIH is 2.8%. And so I've just had two rent reviews recently, and I just went for 2.8% and then rounded it down to the nearest 0 or 5.
Mhm.
And the tenants were really happy with that. It means my things are ticking on. If they're on a periodic tenancy, I use section 13. It's a statutory notice. You send it to them. You've got to allow enough time for it to be served. I talk to them first, so it doesn't just land on their thing, and they don't have to do anything. They don't have to sign anything. And if they think it's unreasonable, they can go to they can challenge it already now to at the first tier tribunal, and the first tier tribunal can will look to see what the market rent is. They'll have an independent expert advice on that, and then they can either decrease the rent or increase the rent. And
Mhm.
that's a process at the moment. Labour wanted to stop this. So this is when they were talking the Renters Reform Bill. to stop it, so that the Section 13 process would be that the judges could only reduce it and not increase it, because tenants at the moment, it's risky if they go to court because it might actually increase.
Mhm.
And so what the Renters Reform Bill did is it said that you can't have rent review clauses, because rent review clauses are outside of Section 13, and the landlord is entitled to increase the rent by whatever the amount is in the agreement. And the feeling is that this is actually unfair to tenants. They don't necessarily read their agreements, and then they can be locked in and getting a 5% rent increase during a period of low inflation, for instance. I remember seeing that in my first tenancy agreement. I didn't actually follow it. I think my first rent review was during COVID, so I didn't increase the rent. So under the Renters Reform Bill, they were going to stop these rent review clauses. So everybody would have to use Section 13. So when Labour is talking in the King's Speech about stopping or giving tenants the ability to challenge rent increases, and just I've got looking at the words here, the bill will empower tenants to challenge rent increases designed to force them out by the back door, which is, kind of political.
Yeah, yeah, yeah.
Because how do they, it's a bit of a nonsense, because how do they prove the intention of the rent increase? Because you might be wanting to increase the rent because your mortgage is doubled, and you can't afford to keep the property unless you put the rent up. But what I think that means is that they're going to copy what was in the Renters Reform Bill and take out these rent review clauses and say people have to use Section 13, and they'll have it so that tenants don't have to worry about the rent being increased.
Got
That's
you.
my guess anyway, based on the many hours I spent watching Matthew Pennycook, who's now the housing minister, in committee. He's very good, actually, married to a lawyer, so I actually thought he was a lawyer to begin with, because he comes across really well on top of
Right.
his.
Maybe she's keeping on the straight and narrow, who knows?
Well, she's actually co-head of the Law Commission.
Oh, right. Okay. Well, there you go. Um, so it's taking the risk out of the process. Well, we think the direction of travel, it may be
Yeah,
de-risking the process from the tenant,
yeah,
where if they were to challenge the Section 13, that it can be downwards only for them as opposed to
yeah,
upwards as well. That makes total sense. And then there's the ending of the rental bidding wars. I thought that was interesting because that was it felt to me like that was just an off the cuff remark
yeah.
Keir Starmer made in an interview, probably without maybe thinking it through. Maybe that's true, maybe that's not. I mean, what's your take on that?
Well, I mean, there had been a bit of noise about this when the bill was going through committee. It's not the first time it had come up, but it wasn't in the Labour manifesto. And so the problem is that it's very, very difficult to legislate, because I mean, at the moment, if I put a property, if I list a property, I will choose what I think is a fair market rent, and my properties are nice, so normally, right, pushing pushing the boundaries at the top of the market rent, because my properties are so nice, and it's a market rent if you get somebody who wants to let it. And I have had people approach me in the past wanting to pay me more, and I'd not accepted them, because what I have done is, what's important is to get the right tenants. I want tenants who are going to look after the property, be there a long time, put roots down in the communities. I don't want them moving in and out every 5 minutes. And so I have turned down offers to pay more. In fact, I just say to them, look, I'm not interested in offers to pay more. Just put your best foot forward, and tell me why you want to let the property, and it will be for the advertised rent. So but not all landlords are like that, and I think particularly last year, when there was a very low supply and high demand. And I've been told anecdotally it happens a lot in student areas, where people are asked, it's like putting in sealed bids to buy a house.
Mhm.
And so this did happen, but I think it's not universal. But and I read a really interesting blog post by somebody called David Smith from JMW Solicitors, who's he's a really good solicitor, and he talked about the experience in New Zealand where it didn't work, and because instead of like if you're putting up a rent, if you're advertising a property for 1,500 and then you get offers above it and take one for 1,600, there would be nothing to stop a landlord putting it up for 1,600 and then say and then somebody offers below it. So
Yeah.
I can't, and bearing in mind we haven't managed to stop gazumping and
Yeah.
gazundering in the sale of or and purchase of houses. I can't see how they'll enforce it, but it makes a good headline.
Yeah, it does. It makes a really good headline. But just to link up a couple of good points that you've made, it goes back to this also this concept of tenant selection as well. That is far and above the most important thing under this new regime with the direction of travel that we have. Is look at the overall position of the tenant. What they're offering, and it's interesting, isn't it? The relationship between tenants and landlords is one which is really demonized nowadays, much certainly more than it was, say, a decade ago, which is funny and slightly depressing because what's the reality is that it doesn't need to be a relationship that can be demonized. It can be highly cooperative. I mean, we've had people living in in some of our houses, for an enormous period of time, and they care for the houses like their own. We look up, we're highly responsive to their feedback and any issues that they have, and it's a really compatible relationship. And it's a shame that it's demonized.
And yeah, and that's the way to do it. And I think when landlords are hearing all this noise, they should just forget all the noise and just concentrate on what they can control, which means being a good landlord
Yeah.
and choosing good tenants, looking after them, looking after their house. It's not rocket science. I have really, really lovely tenants, and they tell me when things go wrong. Things go wrong all the time. Well, not all the time, but every couple of months I get one of these WhatsApps. I think, oh God, what's happened now? And something's broken, and I get it fixed. But it's I've not had a bad experience. I've not had one day's rent arrears in the 5 years I've been doing it, and they know that I will jump on things straight away. If there's ever a delay, it's not for me. It's just because sometimes it's really hard to get tradespeople out to do small jobs. And so
Yeah.
I actually went on a plumbing course so I can do some of the small stuff
Good on you.
myself. I did it at this place in Dartford where you can
No.
go in and get your MVQs and things. And so the first week of the course, I did, and then the people went on and became, proper plumbers. And
Yeah.
so I was there with every type of person, and
Yeah.
lying on the floor, changing taps in a bath and stuff.
It's only a pity there's such a distance between Kent and Leeds. Otherwise, I would be sending you a WhatsApp message next week. No.
Well, and actually there are other landlords doing it. I learned to tile as well. So my new skill, which I'm going to put to use very soon, is replacing silicone. And I've learned how to get that perfect beading with a little profile tool and the technique how to do it. And so for the inspection or maintenance visit I did this week, she said that some of the silicone needed replacing. And I thought, great, I don't need to have a plumber come in and do this and charge me a fortune. I'll come and do it myself.
Oh, I absolutely love it. So as to the rest of the King's Speech,
Yeah.
the balance, the majority of the balance of it relates effectively to housing standards. I mean, there's some other things as well in there, but there's a
Yeah.
drive obviously to raise standards, which is obviously no surprise. And I think it's to be welcomed. Like we all want people to live in good homes. That's the truth of it. So do you want to talk us through the sort of headlines of that?
Yeah, sure. So the up until now, there's been something called the Decent Home Standard that has applied to social housing only. And
Mhm.
so that little boy who died as a result of inhaling mold in his housing association flat, that local housing association was actually bound to have property that complied with the Decent Home Standard. But the Decent Home Standard itself has never applied to the private rented sector, although we are supposed to make sure that there aren't any hazards, and there's a big long list of hazards that they've been working on trying to simplify, because it's quite complicated. And it's complicated, and when I try and write about it, I think, oh, it's all these big long documents. They need to make it more understandable. And so as part of the Renters Reform Bill, they decided to apply the decent home standard to the private rented sector. And the thing with the decent home standard for social housing, it was really restrictive, because it had a lot of detail on what reasonably modern facilities are. For instance, and I'm just checking my notes here on the screen, the kitchen had to be under 20 years old. The bathroom had to be under 30 years old, and there had to be adequate insulation and all this sort of thing. And so what happened, the last government, so Michael Gove, launched in September 2022 a consultation on how to apply this to the private rented sector. And the idea was that they weren't going to stipulate the how old the properties were, but they were just going to say that it was a kitchen with adequate space and layout appropriate to the property, and appropriate this kind of thing. And but they never actually published the detail of it. And so that Labour are lifting that into the Renters' Rights Bill, but we don't exactly know what that is. And then separately, there's this thing called AWAB's law that's named after the little toddler I mentioned. And last year, there was a law brought in, which applied. It was Section 42 of the Social Housing Regulation Act 2023, which implied an implied term into social housing tenancy agreements, so that landlords are required to fix reported health risks within specified time frames. And the Department for Levelling Up, as was, went out to consultation on that, and we didn't have the results of that by the election. And so what Labour are going to have to do is figure out how that's going to apply to the private rented sector, because we don't have teams of maintenance people that we can call on like local authorities do. And I know for myself, fixing damp and mold is really hard. It's like whack-a-mole. There's often more than one reason. And I know a lot of landlords think it's just due to tenants not opening windows, but often it's way more complicated than that. And even when people have got those PIVs that extracts the moisture, they can still have damp and mold. There might be water ingress, there might be leaks, might be all sorts of problems. So I think this is going to be something that's really important to find the detail out on.
I mean, and that's an interesting question. I suppose, when are we going to find the detail out on these things? How long are we going to wait?
Yeah, well, because we found out in the order of business that the bill itself isn't going to be have its first reading before the end of July, when the Parliament goes on holiday. And so what that means, we're not going to see the text of this new bill until the autumn. And the bill, if it's anything like the Renters Reform Bill, it has some detail in, but it will say decent home standard to be set down in regulation. And so until we get the regulations, and before that we need the results of the consultation, we won't know. And so this was going to be the same with the Renters Reform Bill, that the bill itself was just a structure, and it's not even a standalone bill, because most of it was saying, delete this section here, insert this section there into the various housing acts. So it's not easy to read.
And probably not imminent as well. We're gonna have to wait, aren't we? We're not.
Yeah.
Other things in the bill. Well, what's probably the final thing we'll pick on in the bill? Let's talk about the ombudsman scheme. So what's the plan with the private rented scheme, ombudsman scheme?
Well, this is another thing that was in the Renters Reform Bill, and It was another ththat was out to consultation, and I remember actually reading the document that went out to contractors. I can't remember when exactly; it was sometime last year. That actually showed that they really didn't know how the ombudsman scheme was going to work. What they have said is that it's going to be run by the ombudsman who runs the social housing ombudsman. And I mean, it is really confusing because you're still going to have the redress schemes for letting agents, and there'll be overlapping jurisdiction with the landlord ombudsman as well. And in the Renters Reform Bill, it referred to landlord redress schemes. Didn't use the word ombudsman, but and it was going to be all set out in regulations, which we never saw. But there's some fairly hefty penalties if people landlords don't join the landlord ombudsman. So
Mhm.
that's another watch this space, I'm afraid.
Yeah, and keep us posted. But there isn't obviously a tenants ombudsman, is there?
No, and that's a really good point. So I think part of the problem at the moment is that um, landlords don't have redress when tenants don't comply with their part, their obligations under the contract. And
Mhm.
so this ombudsman was just going to be hearing complaints by tenants about their landlords and not the other way around. And often when you have disputes, it's it, it's not always clear who's right.
Mhm.
And there might be a bit of wrongdoing on both parties, and the landlord wouldn't be able to complain about the tenant except in defense if the tenant takes them to the ombudsman.
Interesting, very interesting. So do we think that the ombudsman will make public findings against a landlord? So will we
Yeah.
get a time where you can search a person's name and it will record the public findings?
Yeah, well, it didn't get into that kind of granularity,
Yeah.
and because you can do searches for court cases and things to see if somebody has been prosecuted for not having a license.
Mhm.
So I don't know. I mean, part of the problem with the letting agent redress schemes at the moment is there's not much of a case law. It's
Yeah.
very difficult to find out. I was trying to research what have the redress schemes said about unfair terms in contracts with letting agents, and there's very little information on it, even though I know anecdotally that lots of landlords have taken their letting agents to the redress schemes and have won, but
Mhm.
there's nothing tangible. I mean, I think it would be really good if there is a case law that explains the decisions, and because sometimes the laws aren't very clear and a
Mhm.
lot is down to interpretation. So it'll be interesting to see what happens.
Yeah. I mean, this will obviously be an unpalatable suggestion, but the public record in relation to tenants, I suppose, is the court record of county court judgments. If a
Yes.
tenant doesn't pay and doesn't satisfy their judgment, then obviously you would go and you would have an unsatisfied CCJ, which obviously will appear on credit files and all the rest of it. So, um, is that the necessary direction of travel to even the balance? I don't know. We'll have to
Yeah,
leave.
I mean, and a lot of landlords don't bother doing that because it's quite a bit of hassle.
Yeah.
So, but yes, and it does seem to be, um, a lack of balance. But one of the tips that I give landlords is when they're referencing, don't just get a reference from the current landlord because the
Yeah.
current landlord may be pleased to get shot at them.
Yeah. They might be
Speak,
incentivized.
yeah, speak to the one before, and the one before that. If
Do you know,
they
that's a
and if
really
they
good idea.
keep, yeah, and to find out, because it's a bit like when you're trying to uh if when you're trying to hire people, and somebody might have been asked to leave, they might have had a compromise agreement, and
Mhm.
and you don't know, and then HR will just give this very bland reference. They worked here from X to Y months, and had 4 days sick leave or something like that.
Yeah.
But if you speak to some of the earlier ones, then you might find out more information.
Oh, that's a very handy tip. And again, we find that in your blog posts, which I'll
Yes.
link to in the show notes. So let's thank you very much for that. Let's leave the King's Bill for now. I think that's really, really useful. And the message I've got from it is really let's watch this space. Let's not panic. Let's not overreact. Let's allow this to unfold and let's see what comes of it. Um, so we've only got a few minutes left to finish on, but I think I'd like to circle to a topic that we kind of really began our conversation with over LinkedIn, which is um, I, I think whenever I'm asked about, what's the single bit of advice you would give somebody, given the fact that, you're a lawyer for a decade, my advice is always read the contract. Like, read the contract. I've seen you make some really interesting observations about the contract that exists between the landlord and letting agents. So, you
Yeah.
want to just take us, just to give us like a couple of minutes of your thoughts on that. What as a landlord, what approach should they take to understanding the relationship with their letting agent and the contract and the terms that you might expect to see and ones which you would raise an eyebrow to?
Yeah, and I have a detailed blog post on a guide to the small print of letting agents. I think that the unfortunately a lot of letting agents don't focus on providing such wonderful service that people don't want to leave. Instead, they try and lock in landlords to make it difficult for them to leave. And so you see this particularly with some of the big ones with rent collection where you can't terminate. And then other ones, if you're managing, if they're managing it and you want to take over the management 5 years after the tenant has moved in, and they either say you can't or they want to charge a lot of money for it. And this is a really common term. And under the law, if you're what's called a consumer landlord, which is you own it in your own name and it's not your main business, you've got another job, you're not a professional landlord, you do have some protection under the Consumer Rights Act, which means that the letting agent can't enforce it against you. But the problem is it's really difficult to argue that with the letting agents, that this clause that locks me in is unenforceable. So instead, what landlords should do is, before signing with the letting agent, is to go through and have a look for all of these clauses and unfair charging. Often they put a markup for arranging repairs and things, and just to check to see whether or not it is fair. And I know that sometimes letting agents very rarely put their terms and conditions on their website. They'll put the fees because they have to, that's the law, but they won't put their terms and conditions. So if you're thinking of using a letting agent, ask them to send you their contract. Often they only do it at the last minute. It happened to me myself when I in the days when I used letting agents. And if there's anything you don't like, then highlight it and ask it for it to be taken out. If they want to tie you in forevermore and not release you, then go somewhere else, because there are lots of really good small letting agents who are still Propertymark qualified, etc., who won't have the same turnover in staff and really care about you as a landlord and your properties and your tenants, and move to them. If I just wouldn't do business, I would refuse to do business with somebody who has unfair terms in their contracts, because it shows that they don't have you as their customer at the heart of their business. They're just trying to tie you in, and it's the wrong mindset.
Yeah, I think that's really fantastic advice. So obviously, in order to follow that advice, you need to read the contract, you need to call for it. So, I mean, typically quite early on in a contractual
Yeah.
relationship, I will say to the person with a smile on my face, I'll say, just so you know, my inner lawyer needs to see your contract. So we spend too much time with each other, I'm going to need you to email me the contract. And normally most people are 100% fine with that. I have had one time where someone refused to do it, and it was obvious why they refused to do it, and that should be an enormous red flag. If
Yeah,
someone doesn't want
absolutely.
to send you their contract, um, that's obviously an enormous red flag. And then as you rightly go through and highlight, I think it also says a lot about a business, what's
Mhm.
in the terms and conditions. I think a lot is being communicated to you. And so just be mindful of when you're reading those terms and conditions, what is this really telling you? What's this really communicating to you? And I can tell you, I've seen contracts whereby, let's say we at one point we had a lot of HMOs, we had a lot of room by room. If I had signed that contract, it would have cost me somewhere in the region of about £40,000 to exit
Wow.
that contract in exit fees. I mean, that is just an outrage. I mean, I can't, it's difficult to describe how appalling that is. So we all need to read these on contracts. And I think particularly in the HMO space, if unlike a family let where you may have 5 years of a tenancy, if you know on individual rooms you might have 6 to 12 months, 18 months, and you've got that turnover, you really need to read this contract carefully, and you need to work out who is the winner in the room, because it probably isn't the landlord. And you need to check that very carefully and do like a manual calculation. If your tenant turnover is every 6 months, who is making the money in this contract? And is it you as the landlord? Now it might be, but so I think that's definitely, and I just want to re-emphasize your excellent point about shopping around as well. There are some fantastic letting agents. So we use two letting agents. Absolutely, give them 10 out of 10. Absolutely. Um, we've been on a journey to get there. And I think read the contract, negotiate. Um, I was tempted to slightly put you on the spot with like a legal question. The entire contract rule. Could you tell? Do you want
Oh
to
God.
go at that, or
Can't remember.
do you want to
So
leave
so
that
what
to me?
says that you got to oh, I can't remember.
It's that Grizzly one at the end. Well, it's not the Grizzly one. It's the one at the end of that contract, which I think is so important that I think people don't understand what it means. It says the terms of this contract are what is in the written document, and effectively this is the entire contract.
Yeah,
And it's that thing of basically it excludes any
yeah.
oral representations
I
or any
remember now.
contract. I didn't want to put you on the spot. Do you know? I think everybody should be taught that in school, because what
Yeah,
that's telling you is, if the person says, "Oh, don't worry about it being in the contract. We would never make you pay for that," then
yeah,
they take it out of the contract, because
yeah.
by the fact that it's in the contract and the entire agreement clause is there, it means it very much is in the contract, and they very much will rely upon it.
Yeah, absolutely. Because, you know, if it's not in writing, it's as if it never happened.
Yeah.
It's the same, you know, if you have a dispute with anyone, you have to have evidence. If you want to use Section 8 to recover possession, you're going to have to provide evidence. And so if you know, I've done mystery shops when I've called letting agents for my blog when I was doing a bit of research into contract terms, and I said, oh, you know, this contract, you can't actually ever terminate it until the tenant leaves. And they say, oh, don't worry about that. We'd never enforce it. It's like, yeah,
Mm,
right. And of
mm,
course, that person will have gone then. And so you'd need to either have it marked on the changed on the contract, or a proper amendment to the contract. And, you know, that's a really good, very good point.
yeah. Um, and obviously we've got the property redress schemes for letting agents. People should not hesitate to use
Yeah.
that. It's there for a purpose. Anecdotally, I know that I have been told by landlords that they have had findings in their favour from the property redress scheme, but which letting agents have attempted to ignore or appeal, or and so that is not a direction of travel that a good landlord's looking for, isn't it? So I'm almost tempted to say read the contract and ask what their attitude is to the property redress scheme.
Also do a mystery shop, you know, pretend to be a tenant, see how they treat you on the phone. Can you get through on the phone? And and like for HMOs, you mentioned HMOs. Do they actually know anything about the HMO management regulations? Quiz them. How often should we do inspections? Should we send in a cleaner? All of that sort of thing. Because there are a lot of agents who actually don't understand the rules. They don't have any qualifications themselves, and some of them just they just hope that nothing will happen. But the duty on HMO landlords is a lot higher. You have to be proactive with repairs. You can't just wait, as you can with a single let, for the tenant to report it to you.
Mhm. Absolutely. But look, I mean, the positive from this is there's some really great, well, obviously there's the opportunity as you do to self-manage. There's the opportunity like we do, which is just use a couple of really good high quality letting agents who know what they're doing, having read their contract very carefully and discussed any items that need to be discussed. I think we can take a positive away from it. So as we bring, well, look, Suzanne, thank you so much for coming on the podcast. Before we bring things to an end, where should we send these good people if they want to connect with you more, learn more about what you're doing?
Sure. So my blog is called The Independent Landlord, and you can get that theindependentlandlord.com. I do a weekly newsletter that has over 5,000 subscribers, and everything's free. I don't make any money out of it. And so that's Independent Landlord. I also do the podcast Good Landlording. You put Good Landlording into your app, it will come up, and the website is goodlandlording.com. I'm on Instagram and Twitter as indie_landlord. That's INDIE landlord. And yeah, and on LinkedIn, you can probably find me there. You can Google, if you Google me, Suzanne Smith landlord, I come up.
Perfect. Well, look, Suzanne, thank you very much for coming on the podcast. It's been really, really useful. Let's see what develops with the King's Speech, and maybe let's revisit this in a year or two time and see exactly where we've got to.
Great, thank you.
So, ladies and gentlemen, there you have it, the Property and Investor podcast. If you have enjoyed this podcast, which I really hope you have, please do subscribe to the podcast because it allows me to book fantastic guests like Suzanne. And please do follow it, subscribe to it, like to it, send it to a friend. If you'd like to discuss anything arising from the podcast, you can always join me at one of my breakfasts. The link will be below. Thank you very much for listening. Keep well, and we'll speak to you very, very soon.